Hi, my name is Dimple Baca, and I am a staff attorney with the Home Preservation Project of Legal Aid of Northwest Texas.
And I am Kalisha Rutledge, and I'm the managing attorney with the Home Preservation Project of Legal Aid of Northwest Texas. And we wanted to provide you some information regarding tenants' appeal rights in eviction cases.
As many of you may be aware, the eviction process in Texas is very fast. If after attending your eviction hearing, you learn that the judge decided that you lost the case and landlord was given the right to evict you, you can file an appeal of that decision. Filing an appeal is the process that you follow to get another judge in a different court to take another look at your case, as if the first hearing never took place. Either the tenant or the landlord can file an appeal, but this must be done within 5 calendar days, which start on the day the judge decided the case. Both weekends and holidays are included in the 5-day deadline. If for any reason the court is closed on your deadline date, then you should submit the appeal on the next day that the court is open. Some courts close before 5 p.m. each day. If that is true for the court your case was heard in, then you get an extra day added to your appeal deadline, giving you a total of 6 calendar days instead of 5. But you need to call the court to find out what time the court closes to learn if you will get an extra day to file your appeal.
To file an appeal, you can do it one of three ways. The first way is to turn in an appeal bond, which is a promise to pay the judgment amount that's set by the judge if you lose your appeal. This bond is usually set at 1 month's rent. The second way is to pay a cash deposit that is usually equal to 1 month's rent also. The third way, which is the most common for our applicants, is to file a statement of inability to pay. This form is for tenants that cannot afford to pay the appeal bond or a cash deposit. This form is available at all the Justice of the Peace courthouses, or you can contact your local legal aid. This form needs to be filled out completely, and if there is a statement that does not apply to you, you simply need to mark NA or not applicable, but do not leave any of the lines blank. If legal aid gives you the statement of inability to pay, we will usually also provide a legal aid certificate that helps to back up your statement of inability to pay. We always recommend that you file your statement of inability to pay closer to the 5th day so that you can buy yourself more time.
If your eviction was for a lease violation or for being a holdover tenant, which is a tenant who's staying there and your lease has already ended, and you are also not paying rent, you simply file your statement of inability to pay with the clerk's office, and your case will be moved from the Justice of the Peace Court to the county court. This means you will get a new trial before a new judge. With lease violation evictions and holdover evictions, you should still continue to pay your rent as it becomes due. If your landlord refuses to accept rent, then you should put it aside and not spend it. There is no requirement that you get a surety bond or pay anything to file the appeal for a lease violation or holdover eviction appeal. If your eviction was because you did not pay rent, there are other steps you must take. First, when you turn in your statement of inability to pay, the clerk will ask you to sign a document that says you must pay 1 month's rent to the court within 5 calendar days if you want to stay in your home while the case is appealed to county court. You will make this payment at the clerk's office where you filed your appeal paperwork. It's important that you bring the correct amount and use the form of payment that was in the court's letter. You must make the payment before the clerk's office closes for the day. Again, it is up to you to check the closing time with the clerk's office ahead of time to avoid being late and risk losing your right to appeal. After the first payment to the court, you must pay your rent on or before the day it is due, but rather than paying your landlord, you pay it to the court. These payments are held in an account and will be given to the person who wins the case at the county court hearing.
It is important to note that if you do not appeal on time or pay your 1 month's rent on time, a writ of possession could issue against you. A writ of possession is a court order that is signed by the judge that allows the constable or the sheriff's office to supervise while the landlord removes you and all your belongings from your home. Many instances, the landlord will set your belongings on the lawn, the curb, the garbage, or place in a storage unit that you will likely end up paying for to recover your items.
We hope the information provided has been helpful. If you would like to apply for services, you can contact our office at 855-548-8457. Thanks for watching.